Hey, hello, Colorado landlords and tenants. Mark Cunningham at Grace Property Management. We've been taking the last few months and going through a number of bills that the Colorado legislature has passed in the 2025 session that impact you as an investor or you as a tenant resident in Colorado. And HB 25-020 is a bill that was passed that probably will not impact you, but if it does impact you, it's a big deal. It's called Concerning the Enforcement of Existing Landlord-Tenant Law. It doesn't create any new laws governing the tenant-landlord relationship, but what it does is it puts some new enforcement mechanisms in place that if they get triggered because of a property you own as a landlord, you're going to know about it. Now, this came specifically because of one property in Denver. You probably remember reading in the news, this is a screenshot of CNN, about the Colorado apartment complex where the talk was that gang members had literally taken over this apartment complex. Venezuelan gang members had taken over the apartment complex, and they were shaking down the residents, and they were doing all sorts of terrible things. The property was in terrible condition, and the city and the DA went to the property management company and the owner said, I can't even get in. It's been taken over by gang members. And the district attorney's office was very frustrated that they couldn't do more to enforce and to require the landlord to do more on the property. And so this bill is a direct result of everything that happened at that property. So a couple things that this bill does. In the very first paragraph, or before the first paragraph, what it does, big picture, is it empowers the Colorado Attorney General and local governments to enforce existing landlord-tenant laws through civil or even criminal actions. Now, that's a big deal. Criminal actions. That means if you're not maintaining your property, the AG, the Attorney General's office, can potentially come after you for criminal actions. Now, this is a long bill. It's about 18 pages. There's a lot packed into this. For example, in the first paragraph of the bill, it says that it allows a person to access suppressed court records if they simply affirm that they're acting on behalf of the Attorney General's office in investigating violations of state law. Now, that's a big statement. Suppressed court records are supposed to be suppressed. But this bill says, well, if a property has court records suppressed, if someone simply self-affirms they're acting on behalf of the AG's office, they can access those. Why? Because this came into play with this Aurora apartment complex and they weren't able to find things out about it. That gives you just a small taste of the extent of extending the powers and the authority of the cities and municipalities and the AG's office to ensure that you as a property owner are maintaining and taking care of your property, which of course you should be. It allows the AG, counties, and cities or municipalities to initiate legal actions based on property violations. It has to be existing property violations. Now, as I said, for 99.9% of the property owners out there, this doesn't apply because you're taking care of your property, and you should be taking care of your property. For those owners that let their property go into a point of neglect, this is an important bill because it gives some teeth to the AG and to counties and cities and municipalities to ensure those things are enforced. It allows the Attorney General to appoint a receiver on properties where the landlord demonstrates a persistent pattern of neglect. And the bill defines what it means and gives examples of what a persistent pattern of neglect looks like. The receiver can use rents for property improvements. They can even borrow money against the property. They can even sell assets of the property. So the receiver has a tremendous amount of authority in that case as well. So if a property goes into disrepair, and the Attorney General's office determines that, they could appoint a company like us, Grace Management, to be the receiver of that property. We would then be in charge of collecting rents, making repairs, bringing it up to the standard that it should be, and potentially even selling assets. Now, this property goes in, or this law goes into effect January 1 of 2026. It only applies to multifamily properties, and the violations, again, are civil or even criminal. This is a very, very serious bill. If we're managing your property, don't worry. We don't let our properties get anywhere near the condition that would require the city or a state to take over the property and appoint a receivership. But if we can be a resource, jump on our website at rentgrace.com.